My title has changed only slightly in terms of breadth, not in terms of focus. So my new title is The Immunity of Defense Team Members at the ICTR, Lessons from the Jurisprudence of the ICTR, the ICTY, and the ICC. So as you can tell from this title, my paper examines the issue of immunity of defense counsel and investigators working for accused appearing before the ICTR. So international criminal law has long focused on the needs of the prosecution. We've focused on issues such as ways to extend territorial jurisdiction over international crimes, issues such as how to interpret modes of attribution of liability more generously in order to target high-level offenders, and also we've justified at times partial adherence to the principle of non-retroactivity of criminal law in ICL. However, there's an increasing recognition that the rights of the defense must be given a greater focus if international criminal justice can be worthy of the name. An interesting context in which this issue has arisen is the arrest and detention of defense counsel and investigators by domestic state authorities of those working for the accused at the ICTR, as well as for the accused at the ICTY and the ICC. Perhaps surprisingly, the statute of the ICTR, as well as the statutes of the ICTY and the ICC, give strong immunity to the prosecution, but no immunity whatsoever to the defense. So my paper looks at the possible legal sources and scope of defense counsel and investigator immunity at the ICTR, drawing on the case law of the two ad hoc tribunals as well as that of the ICC. So my presentation will proceed in 4 parts. First, I will briefly outline why defense immunity is crucial to the effective functioning of international criminal tribunals, and specifically the ICTR. Then I will turn to an overview of the response of the ICTR thus far to claims of defense team member immunity. And I will argue that the current approach of the judicial chambers of the ICTR, grounding the immunity of defense team members only in bilateral agreements between the ICTR and Tanzania and Rwanda, is unsatisfactory, resulting in unclear and variable protection for defense team members. I will then contrast this with responses to similar claims at the ICTY and the ICC, and I will argue that the ICTR's recognition of immunity is deficient in comparison to that at the ICTY and the ICC, who have both successfully interpreted their statutes themselves to grant team member immunity. And finally, I will argue that the practice of international criminal tribunals may indicate the crystallization of a new rule of customary international law, granting immunity to defense team members, and that this crystallization should in fact be encouraged. The issue of the precise scope of this immunity, which I addressed in my written paper, will be excluded from my presentation due to time considerations, but if there are questions on that, I'm happy to deal with that afterwards. So turning then to the first issue of why is defense immunity required? The ICTR, like most international criminal tribunals, operates in the context of a post-conflict society that is scarred by the commission of the most heinous international crimes. The intensity and scale of the crimes, as well as the involvement of powerful Rwandan actors in these crimes, exposes the ICTR to the use of political pressure to influence the course of prosecution at the tribunal. As a result, both prosecution and defense members are vulnerable to the potential use of state power to interfere with the commission of their duties, and particularly we have seen this done by the laying of criminal charges against individuals who are carrying out defense or prosecution duties. If this state interference prevents the prosecution or defense from carrying out their duties, of course the tribunal itself is unable to function effectively. Now, the most effective protection that we could give to both prosecution and defense team members is the recognition of immunity from criminal or civil domestic legal processes in relation to acts done by counsel and investigators in the course of fulfilling their duties. Such immunity would ensure that both the prosecution and defense can investigate and prepare their cases as required without threat of legal hindrance. The ICTR statute, like that of the ICTY and the ICC, as I've already said, recognizes the necessity of this immunity for the prosecution. However, the defense is nowhere explicitly mentioned in the ICTR statute, let alone given immunity. As a result, seemingly, defense counsel and investigators are left without any form of protection in the ICTR statute whatsoever. The experiences over the course of the functioning of the ICTR shows that defense counsel are in fact more vulnerable to attempts at interference with their work than the prosecution. And in my paper, I look at 3 key instances in which ICTR defense counsel or investigators have been arrested, detained, and subject to criminal charges, either by the host state of the tribunal of Tanzania or by the forum state of the crimes of Rwanda. And the most prominent issue, that which garnered the most international attention, was that involving Peter Air Linder, a US national who was at the time counsel in the Bagosora case. And Air Linder was arrested while he was in Rwanda, not on an official defense mission, and he was charged by Rwandan authorities with various charges, including genocide denial, which the Rwandan authorities characterized as an international crime derived from the international crime of genocide. And these charges were in part explicitly based on official defense arguments made by Air Linder in his submissions before the ICTR. The frequency of attempts by states to target defense team members with criminal prosecution as a way to influence the course of prosecution is not confined to the ICTR. As I said, this has already happened as well at the ICTY and at the ICC. Indeed, since it's often the case that in international criminal prosecution, that the accused are enemies of the current government of their state of nationality and or the forum state of the commission of the crimes, attempts to interfere with the defense are naturally going to be more frequent than attempts to interfere with the counsel or investigators for the prosecution. So it's clear, therefore, that the absence of an explicit grant of immunity for defense members in the ICTR statute, as well as those of the ICTY and the ICC, does not negate the functional necessity of such immunity. As is clear from the experiences at the ICTR and similar experiences at other tribunals, in the politically sensitive context of an international criminal tribunal, the protection of immunity is needed to ensure that the defense can investigate, prepare, and conduct defense without state interference, and therefore is necessary to ensure the defendant's fair trial rights, as well as to uphold the principle of the equality of arms. So how has the ICTR responded to claims of defense team member immunity? As I said, Article 29 of the ICTR statute guarantees immunity to the prosecutor and to his or her staff, as well as to the judges of the ICTR and the registry of the ICTR. Since, as you all know, the statute of the ICTR is based on a Chapter 7 resolution, this guarantee of immunity binds all UN member states. Therefore, the prosecution counsel and his or her staff are protected by this immunity vis-à-vis practically all states in the world, including the ICTR's host state of Tanzania and Rwanda. In contrast, no explicit grant of immunity is provided to defense counsel in the statute. Instead, Article 29 of the statute says only that, quote, other persons, including the accused required at the seat of the tribunal, shall be accorded such treatment as is necessary for the proper functioning of the International Tribunal for Rwanda. So a clear inequality is therefore established in the statute between the position of the counsel for the prosecution and the counsel or investigators for the defense. In response to the various instances of interference with defense counsel and investigators at the ICTR, the organs of the tribunal have sought to find a legal basis for granting some form of immunity to defense team members, recognizing that this protection is indeed essential for the free conduct of defense and therefore to safeguard the defendant's right to a fair trial. The ICTR judicial chambers have done so by interpreting legal instruments other than the ICTR statute to provide for such immunity. And in particular, they've relied on the Memorandum of Understanding entered into between the ICTR and Rwanda. So the MOU contains a provision that grants immunity to, quote, experts on mission for the tribunal. And the ICTR has interpreted this category of experts on mission to include defense counsel. And it was this provision that was relied on in the Air Linder incident in the Bagosora case. In the Bagosora case, the ICTR appeals chamber asserted the immunity of Peter Air Linder and ordered Rwanda to withdraw all charges that were based on the arguments he made before the tribunal. Air Linder was eventually released by Rwanda, however, only on medical grounds, and Rwanda never in fact recognized the ICTR's confirmation of his immunity. So it's clear there that the ICTR's decision has given some protection to defense team members. However, this protection is very problematic. Firstly, because it is very limited in its territorial scope, as they've relied only on this bilateral agreement between the ICTR and Rwanda. This applies only to the territory of Rwanda. As such, it leaves defense team members completely unprotected and open to prosecution for their activities as defense members in states other than Rwanda. Secondly, there is a very restrictive substantive scope of this immunity as well. Both the trial chamber and the appeals chamber gave a highly restrictive interpretation of Air Linder's immunity in the Bagosora case, only requiring the withdrawal of those proceedings that were based solely on his statements made before the ICTR. And as a result, again, they gave a very weak protection to defense team members. And thirdly, I argue that the reliance on these bilateral agreements only results in inconsistent decisions as to the scope of defense team member immunity, and also opens up the possibility of differing levels of protection depending on which state is pursuing prosecution against defense team members. So this narrow, inconsistently interpreted immunity does not do enough to ensure that defense counsel and investigators are able to conduct defense duties without fear of retribution by state authorities. A preferable approach would be for the ICTR to recognize that defense team member immunity can be grounded in the statute itself, despite the absence of an explicit grant of such immunity. As I noted, Article 29(4) grants an undefined protection to other persons required at the tribunal, and says that they would be given such protection as is necessary for the effective functioning of the tribunal. And I argue that this provision should be interpreted to grant immunity for defense team members given the functional necessity thereof. And in fact, the ICTR appeals chamber has come very close to interpreting this provision this way, but has not taken that explicit step. The benefits of grounding the immunity in the statute itself, as opposed to the bilateral agreement, would be considerable. Firstly, because it would result in a much wider territorial scope, binding all UN member states, but also because it would ensure a uniform substantive scope of protection for defense counsel wherever they are carrying out their functions. So in contrast to the ICTR, both the ICTY and the ICC have interpreted their statutes to provide for immunity for defense counsel and investigators. And they've done so in precisely the way that I've advocated that the ICTR should do so. Both the statutes of the ICTY and the ICC contain provisions essentially identical to Article 29(4) of the ICTR statute, and both the ICTY and the ICC have interpreted those provisions to include a grant of defense team member immunity, despite the absence of an explicit grant of immunity in their statutes. So finally, I will conclude by addressing the question of the customary status of defense team member immunity. Though a definitive answer would of course require a more detailed examination of state practice and opinio juris than is possible in this time, I argue in my paper that the immunity from domestic legal processes concerning the execution of defense duties by those acting for accused at international criminal tribunals may be crystallizing into a rule of customary international law. And of course, this would be particularly so if the ICTR accepted the interpretation of Article 29(4) of the statute that I've advocated. And I argue that there are three possible bases on which to base this possible rule of custom. First, it could be seen as a derivative of the general rule of customary international law, granting all international organizations such privileges and immunities as are necessary to fulfill the purposes of the organization. Secondly, it could be seen as a freestanding rule of customary international law, applying specifically to international criminal tribunals, based on the consistent practice of recognizing such immunity in the statutes of these tribunals and the related treaties as they've been interpreted by the judicial organs of these tribunals. Finally, I argue that it could be seen as a derivative of the accused's right to a fair trial, which is unquestionably protected in customary international law. Of course, what is required for a fair trial will vary depending on the context, However, as I've already argued, the very nature of international criminal prosecution requires immunity of defense team members to ensure that the accused's right to a fair trial, as well as the principle of the equality of arms, is upheld. And as such, this immunity can and should be derived from the more general customary international law rule protecting the accused's fair trial rights. Thank you very much.